Very good. Hello and welcome, everyone. Thank you for being patient. We are ready to get started. I think we've got everything under control now in terms of our technology. So, hi, my name is Janice, and I manage the Low Income Taxpayer Clinic here at Maryland Volunteer Lawyer Service. We're very excited that you're able to join us, and we have a great presenter today, Debra Clark, who has lots of experience in the tax court and is very eager to share that with us. So, Debra, I'm going to let you take it from here.
Hello, everyone. I am a retired attorney with the Office of Chief Counsel. I worked in the national office for a number of years, and then I transferred to Baltimore, where a district counsel, where I tried cases for 6 years. I did both civil, a little bit of criminal, and some collection work, and then returned to the national office. And my last position was at the Office of Chief Counsel as Special Counsel for Litigation. For a while, I also handled motion calendar cases in the national office. So I do have a fair amount of experience in tax court litigation. And thank you all for listening in. Tax court calendars, as you probably know, are held in about 7 cities in the District of Columbia. They are both regular and S. And each calendars are usually 1 or 2 weeks in duration. Generally, there are 3 calendars per year in Baltimore, and even though they may be scheduled for a full week, for the most part, I don't think that the calendars will last that long. Let's talk a little bit about how you got to how your taxpayer got to the calendar call. In VLS, you're going to have basically one of 2 situations. Either you're going to have an assigned case that you've been working on with your taxpayer, or there'll be cases that you pick up at the call of calendar and you meet your client for the first time. There may be some of you who listening in who just have cases, and those are pretty much going to be handled at the calendar call the same way. So while I may address in VLS situation, they're pretty much calendars are handled the same case. The first way, your case ends up on the calendar is about 5 months before the first day of the trial section. The tax court basically looks at all of the cases that it has pending for that city and takes the oldest cases, decides how many cases they regularly put on that calendar. Let's say it's 200, and they send out notices of all that they take those unsettled cases and put them on the calendar. Most cases will end up settling out. My experience working with the Baltimore Low-Income Tax Clinic in the last 3 years is there are no more than 20. There's generally 25 cases or less that are actually called at the calendar. Once the court decides on what cases are going to be on the trial calendar, they will send out a notice setting case for trial. The address that's going to be shown on there, generally speaking, is the Baltimore Court of Appeals courtroom on the 9th floor in the Garmetz building. That is generally where the calendars are held here in Baltimore. Occasionally, we had them over in one of the district court, as in the Baltimore court rooms, but that was really rare. The notice that goes out, there'll be a notice in the standing pretrial notice in S cases and a court standing pretrial order in regular cases. What you're going to notice in the notice is in the notice setting the case for trial is the court is going to encourage the taxpayers to communicate and cooperate with the IRS. And that is going to be a theme that you are going to hear throughout. That's because the tax court really pushes the parties to cooperate. The standing pretrial order that comes out, and I'm going to talk just in reference to the standing pretrial order, but as I said, the notice that comes in S cases is very similar. I suppose it's designed for pro se taxpayers to make it even simpler, but the instructions are pretty much the same. And this order is a guide to both petitioners and counsel handling a calendar case. And you really, if you follow the standing pretrial orders and the directions therein, you'll be pretty much on tap with what you need to do. The order has generally been approved by the court. All the judges, I believe, look at it and they agree on a format. You can find the standing pretrial order on the tax court website in the Q&As. Some judges will modify just a little bit to their own personal preferences. And a sample standing pretrial order is at this particular website if you want to follow along with me. On these next slides, where you're going to see in bold, the caption in bold is going to be the headings or the subheadings in the actual standing pretrial order. And I'm going to just kind of go through those. So the first thing, again, as I said, not for the first time, you're going to hear it over and over again. The tax court addresses communication between the parties. And what this first paragraph really is an introduction of the Brannerton process, which is the informal discovery that is used in the tax court. Brannerton refers to the case, the Brannerton Corporation versus the commissioner. The IRS attorney will generally, if they haven't already done so, once the notice setting for the case for trial comes out, they will generally send out a Brannerton letter to the taxpayer, setting up a meeting, asking them to come in and bring the documents and everything they have. And this is what the tax court describes as its liberal, informal discovery process. Continuances. The tax court used to regularly grant continuances, especially when we were in the middle of the tax shelter wars back in the 80s and 90s. There were so many cases. But what the court and the IRS figured out is that the case is dragged on. So the general policy of both the tax court and the IRS is to discourage continuances. Though I would tend to think that with fewer cases, it might be easier to get a continuance. And I suppose it's always going to depend upon you having good reasons. But the court recognizes that if they say, no, you can't get a continuance, that's going to push the parties to settle as opposed to go to trial. When I was an attorney, the counsel attorneys were told by management not to agree to continuances, so I don't know if that's still the policy. I'm not saying they may not want to, they may not fight it as much as you might think. Sanctions. The court makes reference to sanctions and talks about dismissal being appropriate. Let me say that as a general rule, I think it's unlikely, it's possible, but not probable. The tax court is, after all, a pretty taxpayer-friendly court, and most individual cases are pro se. So I would say that it's got to be pretty egregious. There's a recent case in 2014, Anderson versus Commissioner, a memo decision where the taxpayer was held in default for refusal to participate in discovery. The government sent them 2 Brannerton letters. The first one they sent, and then the government, in this case, was originally docketed Seattle. The government, and it's not clear why, asked for a change of place of trial. The taxpayer objected. The court scheduled they were scheduled a conference call to discuss the motion to change the place of trial, and the taxpayer didn't respond. Well, that is a fatal error, not responding to the court. It's bad enough not to respond to the taxpayer. They did to the government, but they didn't respond to the court, and the government sent another grant. The court allowed the motion to change the place of trial. After that, the government sent a new Branner, and the taxpayer still didn't respond. That is that is the kind of situation you would be in to see a dismissal. Stipulations. The standing pretrial order says that to help the efficient disposition of all cases on the trial calendar, they want to encourage you to stipulate. And so to the maximum extent possible, the court wants the facts and the written evidence agreed upon. If the case is going to trial, the stipulation should be signed and ready to lodge with the court at the call of calendar. But if you've already agreed on a trial date, it's possible that in those instances, the stipulation may be ready and filed before the call of calendar. But if it's specially set, the court may say that you can file the stipulation at the call of calendar. Even if you just pick up a case at calendar call, you can agree to stipulate certain facts: the return, the taxpayer's place of residence. Those are the kinds of things that the court likes to see stipulated to. Trial exhibit. The counsel tries to adhere to this rule. So the court provides, the court's standing pretrial order provides that you shall identify in writing and exchange all exhibits at least 14 days before the trial session. Court wants them stipulated, exchanged, and, if at all possible, stipulated to. If it's not going to be stipulated to, it should be marked as petitioner's exhibit. And I will say that the government's attorney is likely to argue, if you do not present it within the 14 days, the government's attorney is very likely to argue that you should not be allowed, the taxpayer should not be allowed to offer the evidence. I mean, here again, the tax court understands in many cases when it's dealing with pro se taxpayers. Some judges will hold you to it very strictly. Others will give lip service to it, give the taxpayer a lecture and then allow the document in. But it's best to try to exchange all documents as soon as or earlier, the better. Pretrial memorandum, when filed, is due not less than 14 days prior to the call of calendar. If the case is not settled, in general, the IRS attorney is going to file the pretrial memo, even if they think it might be settled. For example, if the case is still in appeals, the appeals officer says, oh, I think this case is going to settle. If you're within the 14 days, the government's attorney is probably going to file that pretrial memorandum. Under the rules, a pretrial memoranda must be filed by both parties in a regular case, and the rules provide that they should be filed in an S case. And what happens there is, so for an S petitioner, it's optional, but the government is, in my experience, always going to, it's rare that the government does not file one, I would think. Okay. Final status report. This is something that wasn't in the rules when I was practicing. And it's a blank form that, according to the rules, should be submitted to the trial court and to the opposing party to report a settlement not previously reported to the court. I've never seen one in the last 3 years. I've never heard anybody make reference to one when I've been at the various calendar calls here in Baltimore. Presumably, I would presume that when these are filed, or when most commonly would be filed when a case is still in appeals, and maybe the appeals officer has come to a settlement with the tax court. One of the difficulties with this is it says it has to be filed no later than 3 o'clock on the last business day, which usually means by 3 o'clock on the Friday before the Monday call of calendar. That's when it would be filed. The rule with the tax court practice with respect to witnesses is pretty much the same as with documentary evidence. The court wants you to reveal them in advance to the other side, to the opposing counsel. So they should be identified in the pretrial memorandum. If there's no pretrial memo or order filed, then they should be identified to counsel as soon as possible. Witnesses can be excluded, and government attorneys will ask the court to exclude witnesses who have not been named. Here again, it depends on the judge and the situation. There is, of course, no need to identify a rebuttal witness because in advance, because of course that the calling of that witness is dependent upon the testimony or evidence that's being rebutted. There is a paragraph that deals with expert witnesses. In most of the cases that you would be handling, you wouldn't have an expert witness, so I haven't discussed it, but you can look at the rules with respect to, you can look at the with the standing pretrial order to see what it says about expert witnesses. Settlements. A written stipulated decision document is what is preferred going, and the court wants that if there is no decision, be prepared to state the basis of settlement on the record and at the call of calendar. And the court will then grant a continuance for the parties to submit a signed stipulated decision. Time of trial. Here is, as a general rule, the tax court likes to set the trials in advance. So if you know that your case is going to, be tried, then the best thing to do is to talk to the district counsel, to the IRS counsel attorney, and so you can agree on when you would like to try the case, and then the two sides can call the the judge's chambers, speaking to probably his clerk or the secretary, depending on the practice of the judge, and get an agreed upon date. The IRS counsel is going to be really helpful in this because probably either they're going to be familiar with that particular judge's practice, or because they have multiple cases on the calendar, it's possible that another attorney in the office has already done that, and they'll know what the judge's preferences are. The standing pretrial order says, if practical, the court will attempt to accommodate the request of the parties. Let me say here that if you're looking for a date later in the week, some judges will tell you quite bluntly that they're not coming back. So, as a general rule, judges are going to try to schedule as many trials in the early part of the week. It's advantageous to the judges that they have a calendar in Baltimore. It's so close, they don't spend the night. They go back and forth. And the way most calendars play out, with the number, they're fewer than, I think in my experience, I don't think there's been more than 5 trials, and not in any calendar in the last, that I've seen over the last 3 years. So court doesn't want to be coming back. Judges don't want to be coming back up to Baltimore on Thursday or Friday. Some judges don't. Some judges will be very accommodating. It really depends upon the judge. And it also depends on, I would think, in terms of the convenience of the taxpayer. You know, if you have a taxpayer from Western Maryland and you got to agree for a date and get them down there. But the main thing is, if you have issues about when you want a case tried, you really need to call the court early. That's something that doesn't need to be done at the last minute. The other thing to keep in mind here about time of trial is sometimes, because it is so close to Washington, judges agree to take cases back to Washington. Usually not something that's ready for trial for the calendar, during the calendar, but let's say you pick a case up and you need more time. But then sometimes they're because of the proximity to Washington, they may agree to take the cases back. Just as a reminder, in the tax court, all documents required, except petitions and briefs, are required to be served on the opposing party. The court does not serve. But post-trial briefs are generally simultaneous. So those are sent to the court, and the court serves post-trial briefs. At the call of the calendar, finally, we get here, right? The calendar call is held on the first day of each trial session. The trial judge is going to bring with him a clerk and an independent court reporter. As a general rule, expect to communicate with the judge through the clerk. Because the court is being held here in Baltimore, the judge is very dependent on the clerk to make things go smoothly. And if you have a problem with anything, the approach, I would say, approach the trial clerk. The other housekeeping point to know is the entire calendar call and the trials will all be recorded, and transcripts can be ordered after the trial. Prior to the start of the trial session, the judge will meet in chambers with the low-income tax clinic professors, their law students, and the pro bono attorneys. And the professors introduce their students to them. The judge kind of talks to them, and that happens at every trial calendar just before the call. At the start of each trial calendar, the clerk is going to distribute a list of the cases still on the calendar. Each petitioner's case should be listed there, each case that's not settled. This pretrial documents should be submitted to the court, pretrial settlement documents, should be submitted to the court before the call of the calendar. If the document is signed by both parties, the case won't even be called. You or the taxpayer, nobody has to stay around for that. So the calendar calls, when the calendar call starts, the judge is going to enter, make a statement to everybody, and he's going to instruct the clerk to call the calendar. And the clerk will call the calendar in numerical order, the oldest case first. Each case that the court does not have a record of a settlement in, or that is not previously set for trial. Some judges, occasionally, I've seen them call out a case that's previously set and say that it's set, but that's kind of unusual. Each case, so if, for example, you notice that a number after your case has been called and your case has not been called, then you're going to need to let the court know that your case was slipped, because it's probably not. And at the end of the call of the calendar, the judge will ask, is there any case that's expected to be called and that was not? Any taxpayer, in any case where the taxpayer does not appear, the IRS attorney is going to file a motion to dismiss for lack of prosecution. In most of those instances where they have not been in touch with the taxpayer, the government will already have a written motion prepared to be submitted. If for any reason the government was expecting the taxpayer to show up and they didn't, they'll make an oral motion right there at the call of calendar, and the tax court, and what they should do, good practice is then to tell the court, Your Honor, I didn't have time to submit that motion. I'm going to submit one this afternoon. Ask for more time to prepare to submit one. And that's what it should. And those cases will be resolved. Some judges will right there at that time rule and on the motion to dismiss. Most of them will, if the taxpayer doesn't appear. Good trial practice, the attorney will come in and say, if generally not only will they have filed a written motion, but the best practice is to have the taxpayer called the week before. When I practiced, I would regularly, either I or the paralegal would, on the Thursday or Friday before the call of calendar, I would call the taxpayer and either tell them or leave them a message that I intended to file, that the calendar call was on Monday and that I had not heard from them, and I intended to file the motion to dismiss if they did not appear in court. And that a lot of judges look for that. I've even had judges, Judge Goldberg would tell us if somebody hadn't done that, he would tell the attorney to go and call the taxpayer and tell them if they didn't come in that afternoon, the case was going to be dismissed. I've seen that happen in cases. When the case is called, after the parties come forward and introduce themselves, the petitioner and counsel, the court wants to know the main thing. What the court wants to know is, one, is the case settled? If it's not, is it ready for trial? And if it is ready for trial, what is the status of the stipulation? How long the trial will take? And when the parties would like to try the case. That is what the parties need to be prepared to answer as when the judge asks for the status of the case. If when your case is called, and this of course does not apply when somebody has, if counsel has just picked up the case, then the judge is going to be understand this. But as a general rule, where the case has been on the calendar and the party, let's say you've had the case for a while, the judge will not be happy if the report is the case isn't ready for trial, and nor is it settled. The court's going to want to know what's going on. The assumption is, in those cases, the taxpayer has not, as a general rule, I shouldn't say the assumption is, but as a general rule, that status usually comes when there's a breakdown in communication in the parties, and usually it's for the taxpayer, because very often the government has sent out proposed stipulations, and at that point, you're going to see the judge start to press the parties. The judge will also not be happy if the case is ready for trial, but is for trial, but there's no stipulation. As I said before, despite the fact that the trial session is scheduled for a week, some judges will not be happy if you report that the case is ready for trial and you want it to be tried later on in the week. As I said, I have seen judges say they're not coming back. They're not, you better get ready, prepared to try it earlier in the week. As a general rule, at the end of the calendar, then what the judge will do is he'll go through how many cases he has, how many are for trial. He may mention he may tell you what cases are previously set, and he'll take a brief recess to go back, and based on how much time each case is going to, the parties have projected that the case is going to take, he will then take a brief recess, go back, and come up with a calendar schedule that he wants to have. He'll also, in cases where the parties, where the pro bono counsel has just picked up a case, what the judge is probably going to do is tell you to meet with the client or the potential client to see what you can do and what you think, how you want to proceed with that. That is the time when you will need to talk to the client or the prospective client, see what you think, where you think the case will go. As a general rule, you may have 10 or 15 minutes, and then you got to make some quick decisions on whether you think this case could be settled, it's going to go to trial, and the judge, then you're going to have to report back to the judge and to the government. This is a good time to ask, if the taxpayer doesn't have it, this is a good time to ask the government's attorney if you can see a copy of their pretrial memo, so you get a good idea of what at least the government attorney thinks the issues are for trial. So then you could probably consult with the government attorney and see what their suggestion is, if they're ready for trial, or if they have a settlement offer at that point. And then you're going to have to report something to the court, and it's in terms of where you want to go with this. If you think it's something that you might want to take to trial, when you see what he has scheduled with the other cases, you may be able to ask for trial after the last case. A lot of this, the personalities of the different judges and your taxpayer and the issues, all of that is going to go into play in terms of how much flexibility you have. What you have to remember is the judges want to take back as few cases as possible. And they want, if the case is going to be tried and it's not specially set, they want to try as many cases as they can on that day. They're looking for an orderly process. So just keep that in mind. I have here just a few tips, I don't know, from what I think you might want to consider if you have, in particular, when you're picking up cases or when you have cases that aren't settled. So I would say this. I think the most important thing is that and I think it cannot be emphasized enough, is to pay close attention during the call of calendar to the instructions that the judge gives at the beginning and what he says. And pay close attention to all of the cases that come before you, because you will see what the judge wants. You can watch what he's asking the other parties for, what he's asking petitioners and government counsel. His questions and comments are a guide to what he is looking for. I've been amazed sometimes sitting in calendar call. The judge has asked for certain things. The case comes, and then another case comes up, and counsel, in particular counsel for the government, doesn't have an answer to that question. He doesn't even have it in his presentation. The judge has already indicated to one in a prior case, he wants to know, did you call the taxpayer, for example, or when were this? How long do you think it will take? As a general rule, they have an answer to the question of how long it will take for stipulations. But other questions that a judge might have, pay attention, and he's going to appreciate it and recognize that you are paying attention to what is going on. And I think that's really important. The other thing is you can get a good idea of how amenable or agreeable a judge is going to be to suggestions when you see how he deals with other people. Because you're going to see you're going to see taxpayers that are obstreperous, and some judges more than others will be, shall we say, grumpy, or not going to deal with it. Others you're going to see will bend over backwards to try and help taxpayers. So you'll get a good idea. So I can't emphasize enough being alert to the judge and the signals that you get. I think because of the proximity to Washington, the tax court judges are willing to keep cases sometimes and take them back with them to Washington, and you just have a little bit more flexibility. If you have a case that you picked up, and let's say you think it has a legal issue that might be interesting to handle, because you're in Baltimore, and if after looking at it for a while you tell the judge that, well, first of all, with a legal issue, you may be willing to keep it anyway. If you say this is a legal issue, it doesn't have anything for trial. So he's much more willing to keep it, as opposed to, I think the judges get a little heat about how many cases they return to the docket. They're really supposed to resolve these cases. Obviously some cannot be, and they have to be restored to the general docket. For example, a case that was only docketed 2 months before the calendar went out is a case that you're very likely to get more time on. and that even would be put back on the calendar if you come in and say this needs to be tried, we haven't had time. I think so. Just keep in mind that because you are close to Washington, where the judge is, you have probably some more flexibility than somebody in Minnesota or wherever. I was always amazed when I was in counsel that petitioners' counsel did not either in cases do more formal discovery or ask the government more for documents. I think one, for people who have cases early on during the course of audit and appeals, the IRS may have received documents that you haven't seen. Ask about those things. If you're if your representation begins after a case has come back from appeals, you want to, or you pick the case up at the caller calendar, ask for the appeal supporting statement. I really think you're entitled to see anything that's in the. I really think you're entitled to see anything that's in the administrative file. People don't often ask for it, and of course, a case that you picked up, the court is not going to like you wanting to some case to pick up, see the whole administrative file and take forever. But I mean, you're entitled to it if you want to. You can see those things. You can certainly ask the government to see it. When I've worked with the Maryland University of Maryland Low Income Tax Clinic, we have on occasion asked the attorney handling a case to look at documents that they have, and of course, again, because the taxpayers just don't always bring in the documents, make sure you ask for IRS for a copy of their pretrial memoranda, because again, you want to see what they're saying the issues are. That's a good start. I always, when I'm going to the calendar call and the possibility of that we might get clients, I always take the Master Tax Guide, not because I think it's the best legal research, but when you are at the last minute getting these cases, it helps to have that to just remind you, and in particular if you're going to go to trial, just to remind you what the issues are, and it's a quick reminder of what a summary of what you need to prove. So I find that much more helpful than the code or the regs at that time. Okay, and I also would remind you, if you need copies, I don't know if people do this, but I've done this. The clerk's office, I've gone to the clerk's office like when University of Maryland picks up a case and they have a client and they want a copy. Especially, I'll say I'll get the copy of the pretrial memo from counsel, and I'll go downstairs in the clerk's office and explain to them that we're having a trial calendar with the tax court, and there's no copier, and ask them to make copies. It used to be easier many years ago when the IRS counsel was in the Gormat's court building house, but it's not. So that's what I would do. Remember, the judges are more willing to keep cases that appear that they're going to settle. So even if you don't have enough time, if you've got a case, you pick up a case there, and it looks like it might settle, but you don't know, and you haven't had enough time, if you can tell the judge, it looks like these are settled, and I think that this might settle, even if it's only partial. I think if you say that, the judge is much more prone to maybe give you more time and on that. If you end up representing a taxpayer who's present and has few or no documents, I think consider going to trial. Because of the Cohen rule, you can put your client on the stand and have the client testify. You may at that point have little to lose, because if the IRS counsel is not willing to concede anything without substantiation, and their situation is they're figuring you don't have much time, you're going to want to settle. If you go to trial, you may be able to get more, and you certainly may have nothing to lose. But you're going to have to evaluate pretty quickly, one, the credibility of the tax, you're going to have to evaluate pretty quickly the credibility of the taxpayer. Does the taxpayer make a credible witness? And obviously, it depends upon you being able to get the evidence in that you need. And can you, through this taxpayer, get them in? Well, how can you remind them of the issues, of the items and the dates? The biggest problem with taxpayers' cases is they're not specific enough. They don't give dates and times and dollar amounts. It's obviously not going to be good enough for the taxpayer to say, I deducted $600 for books and supplies, a teacher. Can you elicit from them the type of books, certain kinds of things, if they're businesses, what type of year, what time of the year, what did you do? You need to get them to be specific. But I personally think that in a lot of these cases, some of these cases, you might be able to get a little more than you would get from the government. And the Cohen case, that's a famous case, which basically says that the Cohen rule says that the government, that you don't have to have documentary evidence if the taxpayer can testify. There can be testimony that you can rely on, and that is actually George M. Cohen was the taxpayer there. Okay. And the final thing I would say is, despite the high percentages of wins for the government, remember that the tax court judges are aware that this may be the taxpayer's only contact with a federal court. We used to say often that a lot of judges, that we would go to trial and the judges would give the government attorney heck in front of the taxpayer, and then the case would be decided for the government. And it would make the taxpayer feel good. And I'm not saying that I necessarily see that often, but I do think the court is cognizant of its role and its presentation. So just be aware of that. And and many of the judges will stretch out for the taxpayer. Okay. So that's all I have.
Great. Thank you, Debra. So if anyone has any questions, we encourage you to write them into the question box, and then we'll be able to read them and answer them. So please do that now. There is one question, Debra, about getting a copy of the presentation. So usually we like to put a link or something on our website that has information, and so we'll probably do that as well. I want to draw your attention to the current slide. Thank you, Debra, for changing that over. But our next Tax Tuesday for May, we actually will not have a webinar on that day, but we'll be having our tax controversy training. So that's a little bit longer. It's a 9 to 1 event, and it's going to be held in person here at MVLS offices, but is also available as a webinar as well. So you're also welcome to listen in during that time frame. Well, I think Debra, you gave us a really comprehensive overview of what to expect. Thank you for sharing your wisdom and your many years of experience. I think it's always a challenge for people to go to tax court because it's not something that we see a lot of, because it only comes 2 or 3 times a year. So it's nice to get an overview of things. So thank you.
You're welcome.
Great. Well, thank you, everybody, for listening, and hopefully we will see you soon. Thanks again. Take care. Thanks, Debra. I'm going to stop.